Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
I'm your host, Larry Schooler. This week I'm sitting down with two distinguished guests, Tara Emory and Merrill Hirsh of the Academy of Court-Appointed Neutrals. Tara Emory is special counsel at Covington & Burling LLP and regularly serves as a court-appointed discovery neutral in complex commercial litigation, facilitating resolution of high-stakes disputes, including trade secrets, financial services, and technology matters. Tara has also co-chaired the Programs and Outreach Committee for the Academy of Court-Appointed Neutrals, whose executive director is Merrill Hirsh. He is a hearing examiner, arbitrator, and mediator, and a litigator with over 40 years of experience, representing plaintiffs, defendants, and the government in federal or state courts of over 40 states. Merrill also worked in the Justice Department's Civil Division. He is the chair of the ABA Judicial Division Lawyers Conference Special Masters Committee, the convener of the working group that drafted the ABA guidelines on the appointment and use of court-appointed neutrals in federal and state civil litigation.
Well, Tara Emory and Merrill Hirsh, welcome to Resolutions. It's so great to have you both here with us.
Thanks for having me.
Great to be here.
Let me start with Tara, if I may, just because I think that there will be folks tuning in who are very aware of what a court-appointed neutral is and folks who don't have the first idea. So let's start there. What do we mean when we say court-appointed neutral?
There are many different roles that a court-appointed neutral can serve. They are serving the court, so it is what the court determines and appoints the neutral to do in the order of appointment. There are many different names that you can use. I work in discovery, so I have served under discovery facilitator, special discovery facilitator, TAR facilitator, special discovery magistrate, and that's just in the world of discovery. So it's really just whatever powers the court imbues in the court-appointed neutral in the appointment order and whatever title the court bestows on them. Some court-appointed neutrals are appointed pursuant to statutes, which use particular language and may have at least some default rules.
For either of you, I think it's helpful for us just to understand how the appointments actually come about. I gather there's some circumstances where someone might be placed on sort of a roster or rotation, but there might also be special circumstances. Can you help educate us on just how a court ends up appointing a neutral, how they find someone to appoint?
I'm happy to start. That historically, it's been a very informal process. And so historically, honestly, the problems has been courts would appoint someone they already know, or they'd ask the parties who they know. One of the things that we've been trying to do is change that. Not that everyone who's appointed was bad just because they happen to know a judge, but knowing a judge is a bad way to go about appointing people. So we meaning the Academy of Court-Appointed Neutrals, the executive director of the Judicial Division Lawyers Conference Court-Appointed Neutrals Committee that I also chaired before I got that, have worked on with both the ABA and the world on getting a broader view of how you approach this job and doing things like setting up rosters, as some sort of courts have done, which we consider to be better because people can be vetted and better accepted, and frankly be better choices because they have been vetted and can be trained and can be evaluated, so you improve the quality and even more you improve the acceptance. Or if you're not going to have a roster, reach out broadly. Don't just say, here's my friend Joe, Joe will help you, or get me and name parties, because the parties are going to pick someone they already know, or go to the office of the person next door and ask them who they know. So a better way to go about doing this is to require the parties to come back with a diverse ray corollary compliant list and tell people where they've gone. One of the things that ACAN is doing as an organization is to have all of our members post profiles on our website, so that we are a place people can go to find out of qualified neutrals who they weren't aware of before they started.
And Tara, just from your worked and lived experience, when do you get appointed? How do you get appointed? What has brought about some of the appointments that you've had?
I am doing work for judges who have parties that have discovery disputes, or where the judge expects there may be discovery disputes, or just wants to make sure the parties get off to a good head start and avoid discovery disputes. So I have been brought in by judges I have encountered, and just going out and doing education on discovery in general, sometimes specifically for judges, involvement in thought leadership organizations involving discovery. They find me that way. And then they know the types of things that I am especially good at working to do. So I think discovery has become extremely complex. It has a lot of layers, and at least under the process as it exists under the rules of procedure in our courts, they're just not fit to do the type of discovery that is needed in some types of cases, which there may be tiers where you want to get a head start on certain types of discovery before you move to the next tier. There may be some ways that we can really do targeted discovery and be very efficient and just get things done. That's a lot of what I do. I also have done testifying private party work on validation, so making sure searches are correctly validated and actually do what they purport to do is a big one. So it's no secret to anyone that parties get into arguments over how a search should be done. They fight over search terms, they fight over technology assisted review, they fight over custodians. And so that is where a judge may bring me in to come in and talk to the parties and see if we can develop a cooperative approach that gets what needs to be found without overburdening the producing party.
I want to check an assumption, which is that when we talk about court-appointed neutrals, we might also be talking about a situation where someone's filed civil litigation and a court has recommended or even insisted that the parties try to mediate and appoints someone to do that. Are we talking about something completely different? Meaning, is this outside of the scope of what we mean when we talk about court-appointed neutrals, or is that a piece within the broader umbrella here?
What that is a great question. And let me explain it this way. Court-appointed neutral is a Swiss Army knife. And so it can be a whole bunch of different skills. It could be a purely facilitative job, although it might not be necessarily facilitating a settlement of the whole case. It could be facilitating the parties' discussion about discovery to make it much more efficient, faster, easier, and coming at it with some expertise about discovery, like Tara's expertise. That's a possible use. And so some of these roles clearly involve the skills that mediators have, and they could end up being mediation. What we don't think of this as is something that supplants court-based mediation programs. And so the way we handle that is we have a very broad definition of court-appointed neutrals. But when the ABA proposed a model rule, it put a definition which, broadly speaking, is a court-appointed person, someone appointed by a judge to serve in any number of possible roles, a judicial officer in that sense. We have a carve-out that says, look, we're not trying to supplant court-based DDR programs that operate. Whether you call, I do court-based, I do mediations for DC Superior Court and family cases. Am I operating as a court-appointed neutral in the broad sense? In the narrow sense, it's not an individual judge appointing me. I'm on the court roster for handling these cases. And largely what we try to do is avoid semantic, attempts to split it, because it becomes impossible. You can easily over-lawyer this definition. Think of it as a tool to be used as it is effective, and not to supplant other types of tools that are also effective.
I sort of wonder, and maybe this is a too big of a leap, but I sort of wonder whether a court-appointed neutral is being chosen as much for a form of their expertise as they are for their skills in staying neutral in parties that are in conflict. And that's not to say that, Tara or Merrill, lack skills of objectivity, but I just wonder if, similar to what you find sometimes in arbitration, where arbitrators are often selected based on the kind of law that they most understand, whether you find that to be true also in the world of court-appointed neutrals, where their technical expertise might be as, if not more important.
I think it depends on the judge and what their need is. There are court-appointed neutrals who are brought in specifically to act as an expert and just give the court an opinion on what the court should do. And there are other cases where it's more the case that the judge is hoping that the issue can be resolved if someone knowledgeable and good at doing all the things you're talking about can stand in the middle of the parties. I think the nature in which the court-appointed neutral is appointed, the title they're given can even vary within the same judge and signal what kind of outcome that judge is expecting. So it can be either one. Sometimes it really is a case of one party is going to be right and one party is going to be wrong, and the judge wants someone with specific expertise to go in and give an opinion and help the judge make a decision. And sometimes it is the case, and I think in the cases I work on, it is most often the case that there is a correct answer and you can get the parties to cooperate, to work together towards getting the correct answer. And that's especially true when both parties were not correct to begin with in their positions, which does happen in discovery with some frequency.
I would say, look, we say it is useful to have two-factor identification. Someone can say they're a cybersecurity expert and a neutral, or a business valuator and a neutral, or forensic accountant and a neutral. I mean, any number of different things. It helps because it helps them in whatever role they have to have this expertise. Some things do have right answers. Sometimes the right answer is understanding the party's interests and having them get beyond the positions they start with. And it's a panoply of tools that assist courts that can be used effectively in ways that judges are more limited themselves because they have to be judges. They wear robes.
I want to take a step back and understand the longer view of this. I was shocked in preparing for this that there are suggestions in historical records of this dating back even 2,000 years. That amazed me. And that it even came into being in the United States within the first case or cases of the United States Supreme Court. I wonder if either of you can just speak to how far we've come with the practice of using court-appointed neutrals and maybe some of the evolutions of it as time has gone on.
There is evidence going back to Rome and early Catholic Church adjudications that they appointed neutrals to have expertise involved in assisting judges. The belief is that the idea of having court-appointed neutral, or whatever you call them, used in Anglo-American law came over with the Norman invasion from France. And if that's so, it means that the use of court-appointed neutrals in England predates the use of English. So it's been there as something you could do as a way to help resolve it. And as you mentioned, the very first case on the docket of the U.S. Supreme Court, they appointed some court-appointed neutrals to assist in that case, and it's been recognized. The thing is, it's always been there, usually under the term master or special master, which we're trying to change, because it's a lousy term to be using, and it's a lousy description of someone brought in to help. It's always been something outside of certain particular fields where people are used to it. It's always been something, oh yeah, I vaguely heard some case 20 years ago, somebody mentioned doing this or some judge did that. And it wasn't really until the ABA started looking into this and adopting guidelines in 2019 that people started saying very strongly, this is a tool, use it like any other tool in litigation. Let's figure out how to make it better. That was really a lot of what happened across the ABA in first doing guidelines in 2019 and then adopting a model state, local, tribal, and territorial court rule in 2023. This became more of a let's just use this when it's useful kind of thing.
Mhm. I am curious from one or both of your perspectives about a more recent evolution, which is to say, obviously the pandemic forced many folks to take their business outside of a physical courthouse, even if they were still in litigation. I just wonder what kinds of trend lines have you seen just in the last 5 or so years relative to the deployment of court appointed neutrals and maybe the array of things that you're being asked to do?
Your experience, Tara?
For me, the increasing move to being virtual has made it more possible to participate in more proceedings and more meetings, to get together with parties. I think especially the adding of video where there's more connection between parties and we can be more productive and work through things together. It's not like we couldn't do those things before, but they've just become more normalized. And I think that goes a long way to increasing how much we can do, because I could be serving two different courts in the same day with multiple meetings, just like we can do for any other work. And it does go a long way to making it something that's possible. And prior to focusing as much as I do now on court appointed neutral work, I was doing, as I said, the expert testimony, and it was the same for that. And I was doing a lot of that, I think, during the COVID times in particular. So I could be in a courtroom in Florida and then I could be a courtroom somewhere else later in the afternoon. So just bringing people with certain skills into rooms where they can help is really useful. And I think that's just generally applicable everywhere.
I agree. I would add the biggest change I've seen is that courts are way more open to creative solutions for problems. Bridget McCormick, when she was Chief Justice of Michigan, she's now the CEO of American Arbitration Association. But when she was Chief Justice of Michigan, commented that the pandemic, wasn't the disruption we wanted, but it might have been the disruption we needed, because all kinds of states and the National Center for State Courts, and to some extent the federal courts, everyone had to adapt instantaneously because you couldn't close the courts, so they had to figure out ways of doing things. But B, they became more open to things that they had not previously talked about. And we did some articles on how the court-appointed neutrals help with pandemic backlogs. One of the things that came out of it were creative types of solutions, like a process in landlord-tenant cases in Michigan where you have the parties normally go to someone who had expertise in what publicly available funds might there be to work with the parties with knowledge about potential options to help work them through, because during the pandemic, you didn't want to evict anyone, obviously. And it didn't do any good for the landlord to have someone evicted because they couldn't get a new tenant either. So you needed a more creative solution. And that's gone over to, decisions. There's a great program in Arizona about dependency cases where they decide whether to cut off parental rights or have other people take care of kids, where getting a bunch of people who actually, are either concerned about the case itself or knowledgeable about the process to try to work together to figure out solutions is a really good option that you want courts to have available. So I see a lot more of that.
I'm going to come back to Tara for a moment because I'd love for you to think back to the beginning of your career, an incident or a case where you've been a court appointed neutral and thought to yourself, gosh, I'm really getting a lot out of this. I'm really seeing the value that I'm bringing, or the parties are really seeing the differentiated value that I can bring as a court appointed neutral over some of the other people involved in the case.
Yeah, I think right from I'll tell you about the first one. It was for a judge in the District of Massachusetts, and I had done a presentation on search and validation for a group of judges. And he had a case where parties were arguing over search term performance. And so I think as I went in and worked with the parties, what really struck me was how impactful I was able to be. We resolved the issue. Both sides were reasonably happy with the results, and all I had to do was show up and sort of show them the way. That was all that they needed, and we were able to resolve. It was interesting for me to see what they had done I've been in the discovery trenches for a long time, and I am, I think, empathetic when things do not go exactly according to what the looking backwards, the plan should have been, and really trying to see why a party did what they did and where we go from here. And I think that process is always enjoyable to me. You get to connect with the attorneys. Sometimes it is very challenging. In that first case, I was lucky, but I've certainly run into parties where there is a lot of hostility. There may already be a lot of history where things have really gone off the rails, and I am coming in the middle. But even there, I think trying to convince everyone that we can all be on the same side with discovery. Discovery is a little bit different than other things because we're not here generally to argue the law. And I tell them, don't even bother arguing the merits to me because it's not going to help you. I just want to see discovery get done. And so we work together on the right steps. What I can do is come into a case and maybe there's tens of thousands of documents for a search that both sides thought they agreed to or are trying to work through what to do next. And we may get that down to just a few hundred documents that both sides actually agree. This is where the meat will be. If there is anything good to be had, this is where the focus should be. And if we find anything here, it may take us in new directions, but this is a good first step. And so what we've done is we've instilled confidence in the requesting party that they're actually getting what they asked for, which is very questionable when they were faced with the other side trying to sort through tens of thousands of documents without the knowledge of how to do that accurately and efficiently. And we've taken a burden off of the producing party who hopefully looks at that and can go back to their client and say, we did a good thing. We worked with this person, this court appointed neutral, and we really had a good result for the client because we didn't spend tons of money looking for things that were in the wrong places. It's not always possible to make cuts like that, but I think I know enough about what the data looks like and have sometimes somewhat creative approaches. And sometimes we're even trying to prove a negative, which is really difficult. How far do you go? And taking into consideration things like proportionality, the data, the burdens, and what comes together is something that I think the parties really did need help doing. So I like feeling like I am facilitating justice and helping judges and helping the parties get through that system the way it was intended to work, which is so hard to do today with how complex data is.
I do want to come back in a minute when we talk about Ken's upcoming event to this whole notion of de-escalation of hostility. I was struck by the way the schedule for the event includes some of those topics. I also am curious whether you can remember a circumstance where you felt as if the parties, whether that be the actual parties, the attorneys, whoever, were really pushing back on your being involved. I certainly, in my practice, have had experiences where folks thought it was a waste of time to be in front of me, or that my involvement wasn't really going to be helpful. And whether you've had to navigate something like that, where folks just really didn't think that a court-appointed neutral was an appropriate.
Even if they thought it, maybe they thought it best to keep to themselves at that point. Some of the cases I've been brought in, I was recommended by the parties. They among themselves decide that they want this service and that they consider me, they may consider others, and the judge may ask them to go find some people. I have not had anyone being directly hostile to me to my face so far. I fortunately cannot comment on that.
That is fortunate. I think the three of us have been in this field long enough to know how varied the conflicts and disputes are that can come before us. I know Merrill does some family work. I do some community work. I guess I'm wondering if you can think of an example where a case that you were able to work on as a court-appointed neutral sort of moved you emotionally or just left you feeling that you had had an impact beyond just the surface level of more efficiently and effectively resolving an issue, but where you could see some value more powerful than that.
Go ahead.
Well, I mean, I've had cases, certainly I've had mediation cases and arbitration cases. I tend to look at it a little differently. And I can say, because I also do commercial work, and it's easy to say, all right, family case, you not just, your goal isn't so much to work out the immediate dispute. These people are there with a 3-year-old. They're going to be raising this 3-year-old for 15 years after this. So what you really want to come out is how do they solve the next problem and the problem after that and the problem after that without needing a court or a mediator to do it. So it's a really different sort of challenge. But I find a lot of this, look, it is critical for people to be heard. All right. It is absolutely critical. And years ago, they started having social science research that said people value the perception of a fair process as much as they value winning. And people are scratching their, oh, that must be nonsense or whatever. Everybody wants to win. And then they now have neuroscience showing the parts of the brain activated by perceptions of fairness and being heard. And one of the hardest things for judges to do, given their dockets and their role, they can't have ex parte contact, is to help litigants feel heard, particularly when 75% or so of the cases in state courts in America have at least one self-represented litigant. And so to me, the experience, whether there's a lawyer or not in matters that I've worked on, because I do arbitrations as well as mediations, of having someone be heard and ironically not necessarily be judged, accepting what they have to say and understanding it. And ruling on the law and the facts, but understanding their situation, to me, is kind of transformative. I mean, it's a big part of the mission of ADR from my perspective.
Yeah, I like that. And I'll add on to it that getting to do this work over time has given me a new perspective on the law, on the discovery process. When I am on one side as a representative of a client, then I can only do what the other side will go along with or convince a judge to do. And so even if the other side is very wrong, we have to be realistic about what is realistic versus what is correct. And that can be difficult to digest in the system. So getting to work with a judge, know what the judge wants, and then come to the parties and make sure things are done correctly is a different type of experience for an attorney. So for me in particular, one thing, and I will eventually have an article, but I feel like our entire process of request for production came out of old times. It actually came out of depositions, which were then applied to paper, and things are so different today with data that parties show up and they have 100 RFPs and they're fighting about 50 of them. So I try to approach many of those with something I call topic first. And we sit down and we just have the parties agree on language that defines the scope of the topics that the requesting party most wants. And just the dynamic of that discussion, which both parties are equipped to have, because it's not about the data, it's just about the scope of the litigation. Let's define what matters. Sometimes there are just revealing moments where one party says, I didn't know you thought that, or you think my client did that? I had no idea you thought that. Let me go look. And there are moments where we can actually move the case ahead by having these discussions and have them understand where the other party is headed. And it also then for each topic, we can develop a discovery plan that is discrete and targeted and efficient and not overly burdensome, instead of this mishmash of putting them all together and trying to hammer out a single process to find everything with maybe a few different limiters on dates. And so I think that goes a long way to getting the parties off on the right foot. And everything that Merrill is saying about parties wanting to feel heard and the effects of how your brain works as a human, I think that our process is a little bit set up for people to fail. They're set up to be in conflict. They're set up to not be able to agree on discovery the way it's currently run. And so I am trying within my process to redesign how we approach discovery where I can, so that the parties are not set up to fail, so that they can come together and collaborate on defining topics. And then from there, it's really up to the responding party to design the searches, and they have to do the work to do that. And I will assist them or oversee or whatever needs to be done to provide the requesting party assurance that this is a reasonable process. But I think we have to start with something the parties can actually try to agree on. And if they don't, we want to know that up front, not at the end. We want to go to the judge right away and say, hey, the parties don't agree on whether this should be in or out. Let's take care of it now. So for me, it is very rewarding to get to work through this process at this level, because it's given me a different view on what can be effective and how to carry that out.
One thing I think I would be remiss if I didn't ask you about is the whole notion of being an attorney and being a court-appointed neutral. To what extent each of you feel, or either of you feel, that someone who isn't an attorney can still function effectively as a court-appointed neutral? Again, we talked about technical expertise. We talked about knowledge of the law and of different parts of the litigation process. I guess I just wonder where you see non-attorneys potentially being useful in the court-appointed neutral space.
But many people who are not attorneys manage to lead productive, happy lives. One of the cool things about this field is you're looking for a wide variety of expertise. For sure, one of the possible expertise is legal expertise, but it's not the only expertise, and it's not necessary in all the roles that people serve. Sometimes people who are not lawyers, who are very good at problem solving and have technical expertise, we try to reach out to a lot of people who are scientists, technical expert, having different technical expertise. Tara, of course, is a lawyer, but she's also an expert on e-discovery, which is its own field. And the Academy of Court-Appointed Neutrals has members who are not lawyers as well as members who are lawyers, as does the DR section. And I think that's terrific. I think there's a lot that can be done, and some roles you would want a lawyer for, but that's true of all things. Some you want a nuclear physicist for, and lawyers aren't all nuclear physicists. So that's the way I look at it.
I want to turn for a moment to the upcoming event ACAN is going to host, the annual meeting in California, because I was really struck by the diversity of topics covered on the schedule, at least as it's proposed now. I noticed things like the use of court-appointed neutrals in criminal proceedings, which I hadn't thought about and would be interested in hearing a little bit more about without you playing spoiler to the speakers. And then also this notion of de-escalation and protest and communication across differences, which are things that I think about all the time in my work. But, we sort of briefly alluded in one of Tara's answers to the idea of dealing with high levels of hostility, even in something like discovery. But those were just a couple of the topics that you're intending to cover at the meeting that I thought were particularly interesting and would love to hear a little bit more about.
Why don't I start, because part of this is begging for an ad for our meeting, so I ought to give it. ACAN is having its annual meeting March 11th to 14th at the International House on the campus of the University of California, Berkeley. The DR section and Judicial Division and Business Law sections are all co-sponsors of the meeting. And we're doing it in conjunction with the Berkeley Judicial Institute, which, if people aren't familiar, the executive director is Judge Jeremy Fogel, who had been the director of the Federal Judicial Center and also both a federal judge and before that a state judge, who really spends his life thinking of creative ways to make courts work better. That's really their mission. And so it's kind of a natural collaboration. We always try to make our meeting engaging and interesting and different from other meetings. For one thing, we don't have breakout sessions. Everybody is in the same room, so it tends to be very communal. And we try to have things that you won't necessarily see done this way. Judge Fogel himself is doing a program that really has two parts. One of it is talking about how you go about talking across differences. And obviously, you can't miss how polarized people seem to be these days. There is a voice that the DR community has that I think is tremendously positive, which is, yes, we can get trolled, we can yell and scream, we can vilify people we disagree with, but we're not getting anywhere. But if we actually want to work through problems, try to understand it, because notwithstanding everything you see, we have people who can work with people who killed each other's kids in Kosovo. If they can do that, they can work with Americans who have political differences. I mean, really, truly, we're not that far, that we have no values to discuss. But people don't approach it that way. They don't listen. They talk. Part of this is to talk about how to do it. And then we're going to have a workshop session where we break into groups, have facilitators, and have people practice this with the goal of improving how you operate as a neutral, because it's a huge skill. To take to any kind of neutral work is the ability to hear and help people be heard. Take it back to your life. Start talking with the relatives who have different political views from your own. and learn how to have difficult conversations so they don't all erupt and people get a better understanding of where people are coming from, even if they walk away different. There's huge success for that. On the criminal use in criminal cases, there are a lot of uses for criminal cases, and they're really good examples because they sort of show you how creative the tool is. One way neutrals have been used is to go with law enforcement when they enforce a warrant at a law office to help avoid having the law enforcement people see attorney-client information. Another way they've been used in criminal cases is to review Brady disclosures to make sure that they're adequate, which has a huge structural advantage because otherwise you've got one group of the prosecutor looking at what the other prosecutors are disclosing. And strangely enough, the defense attorneys aren't comfortable that they've done exactly right because they've had another group of prosecutors look over one group's shoulders. This gives people greater faith in the process. One very creative idea that's been suggested by Judge Resnick in the Second Circuit is to have neutrals involved in plea negotiations to help ensure horizontal equity, because the view is the prosecutors know what they've done in all these other cases. And on the defense side, they don't always. How do you get fairness for the people in the process if you don't have a neutral involved? And Arizona actually has a program that does something along that line. We also have nuts and bolts program on how to be a neutral, program on judges and lawyers and how they react to neutrals. So, how neutrals are used in the California wildfire cases, which is a fascinating example of dispute resolution and dealing with problems. Dean Chemerinsky is going to be speaking. He's the dean of Berkeley Law School, and he's a tremendous speaker. We have some other people coming up, but we invite everybody to come. It's open for non-members, or you can join ACAN. DR section members get a $200 discount off the non-member price.
My very last question would be that I'm sure there will be at least one person who hears this podcast and is thinking, gosh, this sounds fun. I would like to be Tara or Merrill when I grow up. What steps should they take to become court-appointed neutral?
Start, Tara.
They should join ACAN to start and attend our meetings because we talk about that topic somewhat frequently. I don't think that there is a formula for doing it. Looking to grow my practice as well. So exploring avenues to getting introductions to judges, but also the parties who may benefit from your services, depending what kinds of services you're trying to offer. There are related things like we talked about mediation. So you could try to get into programs like that and then apply those skills in other ways. I think it really depends what kind of court-appointed neutral would fit your skill set and your interests to how you then pursue that.
Part of our mission, and the first part of our mission is to help people become court-appointed neutrals, to help court-appointed neutrals become better, and to help the court-appointed neutral profession better assist the administration of justice. That's our mission. So contact me. I'm happy to set up a call, talk with you about options. Our website is courtappointedneutrals.org. And if you Google Academy of Court-Appointed Neutrals, you find it that way too. And you can find out a lot of information. Our annual meeting is a great fun thing, regardless of whether you're planning to do it. And I'm happy to talk. It's also useful to get dispute resolution training. Having a better understanding of dispute resolution makes you better at the intersection of dispute resolution and courts.
And if I may add to the flip side of that, I just moderated a great panel at the Georgetown Advanced E-Discovery Institute on using court-appointed neutrals. And we went over the types of provisions that exist in appointment orders and the implications of that for the parties. So if it's the party's choice to have a court-appointed neutral, then they may want to understand the different ways they can actually ask the judge to set that up through a proposed order. And if you're just in a group of people who are interested or would be interested in understanding what court-appointed neutrals do and the value that they can bring to a matter. I'm a co-chair of our program committee. And so we can come in and put on a program for your group and teach them about whatever you think may be of most interest to them so that they can have a better understanding of how they may want to use court-appointed neutrals or seek to have them appointed in their matters.
thanks for being our guests on Resolutions. We appreciate it.
Thank you.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.